All right, good afternoon and welcome to our last DRSCU session of the year. Today, we will be talking about your rights and community access. Our presenter today is one of DRSC's senior attorneys, Anna Maria Connor. She's going to leave about 15 minutes towards the end for a Q&A. If you do have a question at any point, go ahead and send it to me. And I will moderate those questions at the end. Please note this session is being recorded and will be posted on YouTube afterwards, so please don't put any personal information into the Q&A. And at this time, I'll go ahead and hand it over to Anna Maria.
Good afternoon. I'm glad to see everybody here. I hope you'll enjoy our session on your rights and community access. Okay. So let's talk a little bit about DRSC, what we do. You'll see this whole list here, and the mission to the right: protect and advocate the legal, civil, and human rights of people with disabilities in South Carolina. So what does that mean? It means that we work in several different areas. We provide information and referral services to people so that they can learn about their rights. They can learn sometimes where to go if we can't help them. And sometimes it may be an issue where literally they just need some technical assistance and they can solve it themselves, which is that self-advocacy assistance. We provide training like today, and we also provide live sessions. We look at legal advocacy and support. So it may mean that we open up a case on your behalf or behalf of the person with the disability. And again, it could be that we just support the legal advocacy. Sometimes it's actually providing technical assistance to attorneys who don't work in our areas all the time and don't feel comfortable with issues under the Americans with Disabilities Act or issues concerning Medicaid or other areas. Public policy work. Really, that's a number of different things. It could be educating policymakers like legislators. It could be congressmen. It could be state legislators. It could be going in to talk to the head of different agencies in the state to educate them and to ask questions and to bring up the issues that concern people with disabilities in South Carolina. We also do monitoring and investigations, which is something that is one of our core work areas. All the laws that created us originally, the federal laws, required that we do monitoring investigations to prevent abuse and neglect, particularly in facilities, but also in other areas. We also have the Representative Payee Program, which is a special program with a special team through the Social Security Administration to look at how representative payees are handling the benefits for the person that they're working for. And we have the Client Assistance Program, which is the program which allows us to assist people who are trying to access services from vocational rehabilitation, the state agency that's supposed to help you prepare and go to work. Okay, so the areas of assistance are pretty broad. We've already alluded to some of them. Abuse, neglect, and exploitation is one of our first areas of work. And again, that was from the very beginning and one of the reasons for our existence. So it can be abuse, neglect, and exploitation prevention in any area of the state, as well as in facilities and in community settings and educational settings. We work in education issues, including post-secondary. Is the child, for instance, when they're getting ready to go into public schools, are they getting evaluated for potential disabilities? And then, if necessary, is an IEP being developed? Do they need a 504 plan? Do they have choices about education? Employment and vocational rehabilitation, again, are employers discriminating against someone as they apply or as they develop disabilities, either through aging or accidents or whatever, and are reasonable accommodations provided? Vocational rehabilitation services, and that can include services from the Commission for the Blind and others. Home and community-based services. This is particularly relevant today. It's part of our work under Medicaid and under the ADA, and it also is an area that is combined with that Medicare and Healthcare tab that you see there too. And that's really looking at whether or not people are aware of the difference between living in an institution and living in the community, and do they have access to the services that would let them realistically make that choice. And one of the big ways that you do that is under Medicaid and with other health care planning. So that's an area that we touch upon quite often, Medicaid in particular. The ADA, which deals not only with the employment we talked about and the community integration, what I call the larger community integration, getting people out of institutions and keeping them out, but also the day-to-day things that you want to do. Can you effectively communicate? Can you look at a website if you have visual issues? Can you go into a courthouse? Can you go to a movie theater? Can you go to a park if that's what you want to do? And all of the other things that basically everybody in this country wants to access and make choices about, wants to do as a part of their daily life. Do you have that opportunity? Assistive technology. This is a really big issue for us and our clients. Do you have devices that will enable you to do the things that you want to do on a daily basis? And it could be as simple as a device that helps you reach. It could be a wheelchair and a very complicated power-driven chair. What are the concerns about assistive technology, getting it, and also keeping it up and repaired and being able to use it? And voting, again, a really important issue. If we don't have a voice, if we can't vote, then nobody will hear us and our issues and our rights can be infringed. So do you have the ability to vote, first of all, and do you have the ability to actually get your vote out there and get it recorded? So can you access the polling place once you retain the right to vote? All right. For those of you who don't know, all of our services are free because we're a private nonprofit and we do have statewide services. We are independent of all agencies that provide treatment or other services to people with disabilities. We work and collaborate with those people quite often, or those entities, but we are independent of them. We are the federally designated and funded client assistance program for South Carolina, as I talked about, as well as the federally designated and funded protection and advocacy agency for South Carolina. So both federal and state law require us to exist and require us to protect the rights of people with disabilities across the state. And we are one of 57 P&As nationwide. We have one in all states, districts, and territories of the country. So let's talk about the rights of people with disabilities in general. You should always have the right to live and work in the most integrated setting. Again, choose where you want to work, where you want to live, the right to receive accommodations in schools, work, and communities, the right to self-determination, and the right to be free from discrimination. Those are fundamental rights for everybody in our country. The ADA in particular came in and said in 1990 that we recognize historically that people with disabilities did not always have the same rights of other people. We took them away, or we didn't allow them to exercise some of these rights, and we didn't believe at times that they had them. So we're going to fix that, and we're going to prohibit that type of discrimination. And we want to work towards allowing people to, again, have the same opportunities that other citizens of this country have. All right, so the first of all is the freedom to make decisions about your health care. You need to be able to talk to your healthcare provider. You need to decide who's going to be your provider. Is it going to be somebody that works with the facility that you're living in, or is it going to be somebody that works through, if you're in a residential setting in the community for people with developmental disabilities, for instance, a community training home too, or a supervised living program setting. Sometimes there are providers that have staff and they might have contracts with psychiatrists and other healthcare providers to support not only the homes, the staff in those homes, but the residents in those settings. And, can you have your own medical provider instead of using that? You should have the right to choose who your provider is going to be, especially if you have a long-time relationship. You shouldn't have to lose that and lose that comfort and the knowledge that that provider has about you and your medical history. You should also have the right to make decisions about your treatment and care as much as possible. So again, you need to be informed about who your provider is and choose that, and then be informed about what's going on with you and give the opportunity to question the providers and make knowing decisions as much as possible about your treatment and care. refuse to participate in experimental research. That's a basic right. And that's in there because historically, again, there are times in our history where we, with both people with mental illness and developmental disabilities, experimented on them both surgically and with certain techniques, where we were trying to develop new treatments. And unfortunately, the people and sometimes their families didn't even know that this was happening. So that is a fundamental right, and it's something that's recognized both in federal and state law, that people can refuse to participate in any experimental research. And also, you want to look at unnecessary physical and medical restraints. The physical part, everybody recognizes. Positional asphyxia, where somebody may restrain you and actually put you down on the ground and hold you down. That's a physical restraint. It could also be wrapping you up. Um, these are things that have been used. Sometimes there's a jacket. Sometimes it's called something else like a papoose board, but there are different items that can be used to wrap you up, and to restrain you. So those are all the physical restraints, but there are also medical restraints. Whenever somebody's given a shot solely for the purpose to calm them down, when they are excited, or somebody decides they're too aggressive or too excited and they're given a quick shot or some other kind of dose of medication just to control their behavior, that's a medical restraint, or that could be a medical restraint. It may not always be called that, but you need to know that you have the right, your family member has the right to understand the difference and understand how chemicals and drugs and other things are going to be used, just like you have that same discussion and that same right with physical restraints. Okay, so let's talk about the independent support versus control. This is a really big issue for most of our clients because, again, being able from the very beginning to think about being as independent as possible, both for yourself and for your family members, is extremely important. And learning as you grow and develop how to make decisions and how to develop a circle of support or people who can help you is extremely important. And the more that we can keep our own independence and the independence of our clients, our family members, the better able we are the better we are able to prevent abuse and neglect. People who have that feel like they have power and some control over their lives believe that they can also speak up. They have the opportunity and they feel like they have enough internal authority and strength to say, hey, I'm not getting services the way I should be. Somebody's not coming over when they're supposed to, or they're not doing proper wound care, or they're trying to convince me to give them money. So the more that we can encourage that independence from the beginning, the better. And there are different tools that exist legally that can support that independence as much as possible. And you can layer them in different ways, and you can anticipate some of them. A power of attorney is a great alternative for that because it is basically a power of attorney is a legal document that we create that says, I'm going to give a specific person the authority to act if I can't act. So, for instance, I might give a power of attorney to my brother in case I'm in an accident or something else happens to me and I'm unable to make decisions. Then he can step in and he can show this power of attorney to the banks if it deals with financials, or to healthcare providers if it has that, or if it combines both. And basically, it will allow him to make those decisions on my behalf as long as I want him to. Powers of attorneys can be changed, they can be eliminated, they can be limited. Again, I'm granting that power to him, but I'm not giving it away permanently. And that's the difference between a power of attorney and a guardianship. A guardianship is a legal proceeding. You have to go to court and get a court order that says we're taking away rights from an individual. And once you do that, it's very difficult for that individual to get those rights back, so they don't have that same control. A power of attorney is a way to get support for somebody and get backups if they have issues. But at the same time, you're temporarily granting authority to another person. So you still retain all of your independence and control. And, and so it's a really good alternative. Advanced psychiatric directives they're basically a different form of a power of attorney. They have that same understanding as you're saying, okay, something may happen to me in the future. I may have a crisis if I have a serious mental illness. I may have go into crisis, and so I'm going to give my brother the ability to come in if I go into crisis and I cannot make decisions during that crisis, then he can make decisions about my care and treatment until I'm out of crisis. The Adult Health Care Consent Act is a law here in South Carolina that steps in if people don't have advanced directives, they don't have wills, they don't have guardianships, and they're adults. So once they turn 18, you are considered an adult under the law in South Carolina. And so you should be making your own healthcare decisions. But again, you may not have the documents in place for emergency situations. So this looks at creating a list of priorities, who can step in and help if something happens to you and somebody needs to make decisions about health care and treatment during an emergency. So it could be first family, it could be spouses, it could be fathers, it could be grandmothers, it could be sisters or brothers, but you start out with the closest kinship to the person. And then it lists from there, it goes all the way down through what happens if there's no family whatsoever, there's no links to the community. And it basically sets up a structure for when state agencies who might be providing care and treatment might have to step in. Do they have the ability to step in, and what would they have to do to show that, first of all, there's nobody else, and then secondarily, that they're going to act appropriately on your behalf. But that law is out there. It applies to everybody in South Carolina, and it is a good backup. Okay. Another area of support, again, is educational rights. So we have the Adult Students with Disabilities Rights Act, and this allows students who are turning adults at age 18 to say, I still want somebody to help me with my educational rights and my educational decisions. And it's a document that they can sign if they have the capacity to understand it, which will continue to allow their parents or other specific individuals that they choose to consult with them, to be at IEP meetings and other things, and to provide them support. We also have the concept of supported decision making, and all of the things that we've talked about before, again, go into play and are ways of providing support for individuals with disabilities so that they can make their own decisions. And that's really what we want people to think about nowadays is, all of us at different times when we're making difficult decisions or we're trying to decide what we want to do in certain areas of our life, we go and get advice. I do talk to my family, I talk to my friends. So people with disabilities ought to have the same right. But for some reason, we've restricted it quite a bit for people with disabilities. So again, we've come up with a concept of supported decision making where you can actually draw up an agreement and basically saying, again, I want somebody to help me make decisions about health care, or I want somebody to help me make decisions about handling my money, and I might choose my brother to help me with the money issues, and I might choose my sister to help me with the health care decisions. Or it could be that they're the same people, but it's building that group of support. And the agreement is just a document that can be used to show that I feel comfortable with certain people in certain areas, and sometimes I'm more comfortable with person A rather than person B, and the document is there. Now, in South Carolina, we don't have a law that says we recognize supported decision-making agreements. We also don't have a law that says we don't recognize supported decision-making agreements. So really, the way the law works in South Carolina, it's basically using the powers of attorney and other documents, the advanced directives and so forth. All of those things are really just tools under supported decision making that you can set into play, and you can add that supported decision making agreement on top of it that shows the whole plan. And you can also use all of those tools and the supported decision-making agreement to anticipate changes as you age and certain things that may happen there too. Because quite often, people with disabilities are living longer and they experience the same health problems that people without disabilities do. They might have diabetes, which causes sight problems. They might have diabetes, dementia, related dementia, or other things, Alzheimer's, and they can actually have a pretty rapid decline sometimes because they have intellectual disabilities, and for some reason, dementia and Alzheimer's can very quickly affect them. So they can actually do the estate planning just like other people and have that set up so that if it happens, they eventually move over into more support from people that they're comfortable with. And the last area where we have a lot of legal support is the representative payee program through Social Security, and that's dealing with those Social Security cash benefits that you're receiving. And again, that's a federal right under the Social Security Administration Act, but also it's a program, and it can be used in the community, it can be used outside of the community, and typically people with the ability do have the right to decide who they want their representative payee to be. You know, do I want it to be my mother? Do I want it to be my mother and my father? Do I want it to be my sister? If I don't want it to be a family member, do I have a close friend, or is there an organization that I might want to pay a small fee to, or a nonprofit that I want to have as a rep payee to ensure that there's always somebody there to help manage the money in the appropriate way for me? Okay, so community integration, again, this is the concept that we've had for a long time, that everybody needs to have a right to live in the community if that's what they want to do. The ADA recognized that as a civil right when it was passed in 1990. And then after that, we had a big Supreme Court case, a United States Supreme Court case called Olmstead versus LC. And it basically said, this is a right that should have been recognized for a long time, and we have a lot of people with disabilities, particularly in this case, two women with both intellectual and mental health issues who were stuck in institutions down in Georgia for years when they wanted to live in the community. Their treatment teams said for years that with appropriate services, they could live out in the community. But the state had set everything up so that they were paying for all the care and treatment and services in institutions. So it basically prohibited the women from getting out there because they couldn't get services. As soon as they moved out into the community, they would lose all services. So the Supreme Court said when you have a situation where you have an individual who wants to live in the community, the treatment team supports that and believes they can live in the community, then the state has to look at trying to provide services in the community to meet those needs. So states need to develop ways to begin shifting institutional dollars over to communities and other things. And they need to show that they're doing this at a reasonable pace. Because again, people were already trapped in institutions for decades, and you have new people coming, being born with disabilities and developing disabilities, and they're all caught in that trap. So states need to come up with a plan to show how they're developing community services so people have a true choice. So how do you pay for that integrated care? How do you fund those things? The biggest way in this country that we fund community services is Medicaid funding. And it's extremely important for our clients to be able to access Medicaid funding. It's going to pay for a lot of different things under state plan services. A state plan is basically the state insurance plan under Medicaid. So then that state plan is going to say, okay, if you can show a medical necessity for something, you may get a service for that. So if you need nursing, you have a medical necessity for skilled nursing, which is 8 or more hours of nursing services a day, then you might be able to get skilled nursing. And where are you going to get that? Can you get it in a nursing home? Can you get it in the community? Medicaid is the way that you try to get those services in the community. So you might be able to get that under the state plan. But what happens if the service is something that's not in the state plan? The way Medicaid works, the state comes in and works with the federal government to develop that insurance program, and they get to choose optional services after they've decided to do their Medicaid program. So there are some services that you don't have to have in the state plan. So Medicaid waivers were created several years ago that will address issues and that will look at individuals within the Medicaid system who need additional services. They just can't be supported, especially as adults, with the services through the state plan. So you're asking the federal government to say, I can treat some people more special than I treat other people and give them additional services or additional hours of services or additional monies to provide those services. And that's what a waiver is. It's waiving certain requirements from the federal government and from the federal agency, the Centers for Medicare and Medicaid Services that oversees Medicaid plans. We have 7 Medicaid waivers in South Carolina. One of the biggest ones is the waiver for intellectual and related disabilities. We also have a head and spinal cord injury, and we have waivers for people that are elderly, what we used to call elderly and disabled, but they don't have they don't have an IDRD diagnosis, an autism diagnosis, or head and spinal cord injury. And there's some other ones, but those are the biggest examples. Unfortunately, we have waiting lists for those services because, again, the way Medicaid works, the state actually has to allocate the state dollars, and the state dollars have to be spent first, and then the Medicaid funding can come in and pay for the rest of that, the cost of that service. So it's very important for us to all be aware of how much money the state is willing to put into Medicaid and how much in particular they're going to fund Medicaid waiver slots, as we call them. So we know generally how many people can be served on a waiver at any given time. Now, another very important part of Medicaid that a lot of people don't know about is early periodic screening, diagnostic, and treatment. And this is actually something that's addressing the needs of children. We want to give children the best opportunity to develop as fully as possible and to have the best life and the most choices, and basically to grow up to be able to work and live and become taxpayers and be as successful as possible. So the earliest that we can diagnose them through training, through screening, and then get them treatment, the better. So Medicaid basically defines children as anybody under the age of 21. So as soon as you turn 21, you're magically an adult. Again, remember under state law, you're an adult at 18, but Medicaid says we're going to keep you as an adult until you turn 21. So you have a little bit of extra time. But basically, the early periodic screening, diagnostic, and treatment section of Medicaid, what we call EPSDT, basically says that children are entitled to that early and periodic screening and diagnosis. And once the diagnosis has been given and treatment has been recommended, it could be therapy, it could be drugs, it could be a number of different things, then Medicaid is supposed to ensure that that child receives the treatment. And they should receive the treatment as soon as possible once the diagnosis is given. We don't care how it's paid for. We don't care whether you use it under the state plan service or you pay for it under waivers. But it has to be paid for. Medicaid is supposed to ensure that that child receives the treatment. So if the state plan pays for it, then as long as they're not an adult, they should be able to get that treatment through the state plan. It could be that the service doesn't even exist in South Carolina. We might not have any providers to provide that particularly specialized treatment. So Medicaid may have to look at finding a provider outside the state of South Carolina and even paying additional costs for that service to make sure the child gets it. But it's a very important part of Medicaid for children, and it can last a long time. And it's extremely important for individuals to remember about EPSDT and remember too that transitional period. Once you turn 21, you are no longer entitled to services through EPSDT. And so you need to plan for, when have I applied for a waiver? Do I need a waiver? Do I think I'm going to qualify for a waiver? Are there services that I might need that I can only get through waivers? And so get that process started well before the age of 21 so that hopefully you can get qualified for a waiver and already be receiving services under that waiver before you hit 21. Otherwise, there could be a gap, and that could be a really big problem. So a lot of people aren't aware of that. Okay, state law actually says that the person with a disability must be able to live in the most integrated setting possible. So what that means is they need to be able to have that opportunity to engage in the outside world. So we don't want them to always be around other people with disabilities. They can choose to do that, but we want to provide them the opportunity to also engage with people who don't have disabilities. So as we're structuring our residential settings in the community, are we putting them in places where the people who are going to live in those communities have the opportunity to go to school or to go to the local senior center or just the local park or engage at the library? Or are we, again, building little communities where they never see anybody unless they're staff or there's somebody else with a disability? You want the person to have choice. You also want them to have a spectrum of settings to choose from, looking at what's most appropriate for them and what can be supported. But again, encouraging independence and interaction with the larger community as much as possible. Okay. The ADA and employment, this is a big topic for attorneys in particular. There are a lot of private attorneys that represent employers under the ADA, but the ADA only applies if you have 15 or more employees. But again, it prohibits discrimination on the basis of disability, and it requires that employers make reasonable accommodations for applicants, for current employees, all across the board, basically. And again, they have to look at whether or not they can effectively communicate. It could be a device, it could be something as simple as a stool, it could be hours, it could be looking at whether or not they can do light duty. They can work from home or whatever, but they need to engage with that employee or applicant to see if there's a reasonable accommodation that they can agree upon based upon the disability. So there's a lot of protections there. And it's another way to encourage people with disabilities to remain independent. Okay, so state law has different commitment procedures. If you have people with mental illnesses and or intellectual and related disabilities, there's actually state laws that talk about the rights of those individuals, which includes what happens to them if they go into crisis. And there are two different code sections and two different procedures. If you're somebody with mental illness and you go into crisis, there are very specific commitment procedures. And the first one is a very definite right to an attorney or counsel in commitment cases, because basically we're looking at involuntary commitments. We're arguing, if we're filing the petition, then we are arguing that you are in such a crisis that you cannot make a decision, and you need to be immediately put into a hospital, psychiatric hospital, to receive the appropriate treatment because you're a danger to yourself or others. So if that's the question that is being or the argument that is being made, then we're going to make sure that you have an attorney that can represent your rights because you can't argue on your behalf. You have also, again, the right to consent or deny consent to major medical treatment or ECT. And you're looking at the least restrictive appropriate care and treatment for people with mental illness. And under the state laws, there are specific times when those decisions have to be made, when documents have to be filed, and when reviews are done. If you're committed to Bryan Psychiatric Hospital, for instance, for involuntary commitment, then within a few days after you go, you have to have a treatment team there, you have to have things done, and every so often that decision to involuntarily commit you to the state hospital has to be reviewed. You're going to have a lot of reviews early on, and then if you're there longer than a few days or a few weeks, every 6 months, there has to be the opportunity for you to appeal that decision, to question it, and go back into court and try to get out of that hospital. If you're somebody with developmental and related disabilities, there is a commitment procedure. It's not quite the same. There's an applied right to counsel, but the phrasing in the state code is that you are committing somebody to the jurisdiction of the Department of Disabilities and Special Needs, or what is now called the Office of Intellectual and Related Disabilities. And there are some different procedures on how this is going to happen and so forth, but it's a little bit more vague than the mental health. And there's not a lot of understanding or requirements about when that decision is reviewed or what does that mean. Um, but the biggest thing is that it's trying to ensure that you identify individuals with developmental and related disabilities as early as possible. And again, that you ensure that they are attached to the agency that should be providing services to people with those diagnoses. And if at times, sometimes if there's no family members or nobody else who can take responsibility for that individual and the individual cannot do it themselves, then the state agency can step in and say, we are going to provide services to that person. And they still have a duty under that code section to look at the person as an individual and decide, does this person, can they benefit from, again, the least restrictive setting and appropriate care and treatment? So it could be that they're not going to be put into an institution. They are going to be better in a community setting, and that's what they can do and they want to do, or they would probably want to do if they could vocalize their desire, but they can be successful in a community setting. Then DDSN or OIDD may have to actually put them into a community training home or another setting that is, again, the least restrictive. And that's all under state law. Again, there's a right to counsel in there. DDSN has to be involved in the action, just like Department of Mental Health or one of the local mental health centers would be involved in the commitment procedures. And it's all out there in state law. Okay, so another state law that's extremely important is, again, it works with the ADA, but it's independent, is basically the law that says no patient may remain at a level of care that is more expensive and restrictive than is warranted to meet his needs when the appropriate setting is available. So you have to find an appropriate setting, but you cannot trap people in a nursing home if it's more expensive and more restrictive than what that person needs. So if they don't need to be at a nursing home level of care, can they go into an assisted living facility? Or can they go into, if there's somebody with DD, can they go into a community training home? Can they go into a supervised living program or some other setting? Same thing with people with mental illness or any other individual. Is, again, you're looking at level of care that they need, and let's not put them into really expensive homes. Let's not put them into more restricted ones if possible. So some of the other basic rights that are recognized in the community are the right to communicate, and it could be in various ways. When these laws were written, people used what we now call snail mail, and we didn't have cell phones, but basically whether it's by mail or telephone, talking individually, meeting people, whether you're in or out of an institution, you always have the right to communicate. It's particularly important that you remember that you have that right, even if you're in the community, because you want to make sure that the person with disability has the ability to call for help, whether it's to report abuse and neglect, or whether it's to talk about their rights, or whether it's to get help for somebody else. So how do they communicate with people beyond the providers and beyond the homes that they're in? You also always want to have reasonable access to writing materials, stamps, and envelopes, but also nowadays to, again, electronic forms of communication, because that's actually more common. But it will depend on the person, and also you should probably have both, because there are times when it may be more appropriate for somebody to use the writing and to mail it out, use snail mail rather than the electronic form. You also want to have reasonable access to telephones, including the funds or the means in which to use those phones. So in the old days, all houses and institutions always had pay phones or phones that could be used, phones that were lines that were in the house. Nowadays, there are a lot of homes where they don't have those anymore. You do have some phones at institutions where people can make calls, but you also want to make sure that they have funds for a cell phone, or that there are programs that will give them a cell phone and also ensure that there are a certain number of minutes or their service so that phones can actually be used. Okay, so that's an overview of the rights that you have in the community. So I think now we want to see if we have some questions or some things that we can talk about.
Thank you, Anna Maria. Yes, if you have a question, you can go ahead, and put it into the chat to me, or you can put it into the Q&A.
While we're waiting for people to submit their chats, I'll just mention some things to watch out for. There was a big change in the purchasing of durable medical equipment this summer. Durable medical equipment, it's usually it can be pretty expensive. It's usually something that's provided under Medicaid, Medicare, particularly Medicaid for individuals. Wheelchairs and other things. It could be toileting items or shower chairs, things like that. So it's a broad definition for what is a piece of durable medical equipment. But we had a law in South Carolina that said if you're going to use public funds, again, something like Medicaid, to pay for that durable medical equipment, there's going to be a tax exemption if you buy that from a provider of DME, durable medical equipment, if they are a South Carolina company. And the problem with that, of course, is that there's a lot of companies that don't have a sales location in South Carolina, or they may ship things in. We can order things over the internet, and it was impacting sometimes the ability of individuals to get that equipment because providers were having difficulties providing that. So anyway, the legislature worked on that over the past year and fixed that. So as of May 2025, if you use public funds to purchase durable medical equipment in South Carolina, there's not going to be sales tax added on to that purchase price. It doesn't matter whether the company is a South Carolina company or not. It sounds like a small thing, but sometimes the wheelchair can be $30,000. The devices added onto it can add on, and so the sales tax alone can make it the cost prohibitive for individuals and families, because again, somebody else pays first, Medicaid pays last for these things. So that was an interesting change.
Thank you, Anna Maria. Right now, we do not have any questions yet. Again, if you have a question, you can feel free to put it in the chat or the Q&A. And if we don't have any, we will give it just a few seconds, and then we might go ahead and wrap up early today. All right. Well, I think you were extremely comprehensive, Anna Maria. We appreciate your time today. And thank you very much for joining us, and have a good day. Thank you, everyone.